Good evening, students. My name is Rohit, and today we have to start with fundamental rights. Now, remember, fundamental rights is the time-consuming topic because in this we have to discuss each and every article in detail. Okay, but before discussing all the articles of fundamental rights, we will first discuss the basics of fundamental rights. That is, what are the features of fundamental rights? How many fundamental rights were there initially, and how many are at present? Okay, so without delay, let us start the topic. Fundamental rights. And remember, for examination, whether you are preparing for SSC examination or railway or defense or PCS examination or UPSC examination, fundamental rights is really important for all these examinations. So that is why you need to prepare all these articles. Okay, so let us start fundamental rights. Sorry guys, I don't know how come this board is not functioning at present. Just give me a few seconds. Okay, sorry students, board stop functioning. Okay, so again we have to start the board. Okay, so stay with me. Okay, so sorry for the delay. Okay, I hope I am audible. Okay, so let us start the topic, fundamental rights. Okay, so before I start the topic, that this I mean, which part of the constitution deals with fundamental rights, how many articles are there dealing with it? No, first of all we will start with the basic, that why the name of the chapter is fundamental rights. So let us first discuss about the word rights. What do we mean by the word rights? See, rights basically means power. See, in Hindi, we called rights as adhikar. Okay, so rights are the power of citizens. Power against whom? Power against the government. So, suppose tomorrow government tries to impose certain restrictions upon you. So, what will happen in that case? In that case, you can resist. You can straight away say this to the government, that it is my right, you cannot infringe upon the rights. Okay, so rights are the power of citizens, the power against the government. See, the constitution has given the power to the government. Now it is possible that the government might use this power in a wrong way or in a wrong manner. So what will happen in that case? If government becomes tyrant, so in that case you will be in danger. So in order to protect you from the tyranny of the government should not misuse its power. For this, the constitution has given you rights. So rights are the power of citizens to fight against the government. If tomorrow or in the near future, if government tries to misuse its power, then you have the rights. So rights are the power. Now, why these rights are called as fundamental rights? Now, the reason why these rights are called as fundamental, because these rights are mentioned in the constitution. These rights are mentioned in the constitution, and constitution gives guarantee. Okay, the guarantee of fundamental right is given by the constitution. And remember, constitution is the fundamental law of the land. Constitution is the fundamental law of the land. When we say fundamental law of the land, fundamental law means basic law of the land. So it means these rights are mentioned in the constitution, and constitution is the fundamental law of the land. It means basic law of the land. When I say constitution is the fundamental law, what it means to say fundamental law? Fundamental law means all other laws are to be based upon the constitution. No other law made in the future by the legislature shall be above the constitution, because constitution is the basic law. All other laws should be as per the provisions of the constitution. And if any law tries to violate the constitution, then in that case such a law should be declared as unconstitutional, and the task of declaring it unconstitutional is with judiciary. So I hope this thing is clear, that why these rights are called fundamental, because these rights are mentioned in the constitution, and constitution is the fundamental law of the land, and this law of the land guarantees fundamental right, and hence we call these rights as fundamental rights. These rights are called fundamental in another sense also. See, these rights are important for all-round development of an individual. Since these rights are fundamental for your all-round development, that is why we can also call them as fundamental rights. So we can call these rights as fundamental for two reasons. The first reason is these rights are guaranteed by the constitution, which is the fundamental law of the land. That is why these are fundamental rights. And another reason for calling them as fundamental is that these rights are fundamental for your all-round development. So that is why we call them as fundamental rights. So I hope this is clear, that what is the meaning of fundamental and what is the meaning of rights. And one more thing, rights is a modern concept. It is a concept of modern times, because during the time of Akbar, Aurangzeb, do you really think that in front of Aurangzeb you are going to tell that this is my right, you cannot do this? The power of Aurangzeb, Akbar or any other king in ancient and medieval time was absolute. When I say the power of the king was absolute, it means it is up to him whether you will survive or not. Suppose you did something which is not liked by the king, then the king may order that you should be executed. So you will be executed. So during ancient and medieval times, the power of the kings were absolute, and that is why at that time the concept of right did not exist. But this concept originated in modern times, when people realized that there should be no absolute power with the government or with any king. And so these rights were introduced for limiting the power of the government. Okay, so I hope the basics about the fundamental rights is clear. And now we can start with in which part of the constitution fundamental right is. So the fundamental right is in the part 3rd of the constitution. Part 3rd, and how many articles are there in part 3rd of the constitution? There are total articles from 12 to 35. So this is the location of fundamental rights in the constitution. And remember, part 3rd of the constitution is also known as, now this is important for examination, part 3rd of the constitution is also known as Magna Carta of India. So remember this, which part of the constitution is known as Magna Carta of India? So it is the part 3rd of the constitution. Now you may wonder that why this part is called as Magna Carta. What is the story behind Magna Carta? I mean, what is the story? So the story is somewhere around 800 years ago, in 1215, there was a king in Britain and his name was King John. So King John, under pressure, he issued world's first written rights. So under pressure, King John issued world's first written rights, and these rights or these first written rights contained in a charter was called as Magna Carta. So the context in this case is that Magna Carta was the charter issued by the King John in 1215. Now this charter contained the world's first written right, and that was called as Magna Carta. So in that case, in that context, this is known as the Magna Carta of India. So I hope how this Magna Carta came into the picture. This is the story behind Magna Carta. So part 3rd of the Constitution is Magna Carta. Now let us move further. Okay. Now one more thing. Now we can discuss about the features of fundamental rights. Okay. So one more thing. If someone asks that who is the guarantor and defender of fundamental rights, so it is the duty of the Supreme Court to ensure that our fundamental rights are defended. So who guarantees and defends fundamental rights? So Supreme Court is the guarantor and defender of fundamental rights. Now this is also important for examination. I know this is simple, but it is important for examination. Guarantor and defender of fundamental rights. It is the Supreme Court. Okay, now one more thing. Now let us discuss about the features of fundamental rights. So what are the features of fundamental rights? The first important feature of fundamental rights is that these rights are justiciable in nature. Now this is really important. These rights are justiciable in nature. Now, what is the implication of calling it as justiciable? Now, justiciable means anything which is enforceable by court of law. Now, suppose a particular fundamental right is violated. Now, what will happen? The concerned citizen will approach the court, be it High Court or Supreme Court. So, suppose the fundamental right is violated and you approached the court, and now it is the duty of the court to protect your fundamental rights, and for this the court can issue necessary writs for the enforcement of fundamental rights. So these rights are called justiciable in nature because these rights are enforceable by court of law. So whenever these rights are violated, it is the duty of the court to enforce these rights. So I hope justiciable is clear. Justiciable means which is enforceable by court of law in case they are violated. Okay, but you know we also studied preamble, and remember preamble is non-justiciable in nature. So when I say non-justiciable, it automatically means that which is not enforceable by court of law when it is violated. Okay, the court cannot enforce it. So the first feature is justiciable in nature. Now what is the second feature? The second feature is they are not absolute. They are not absolute in nature. So when I say fundamental rights are not absolute in nature, it means fundamental rights can be restricted. Okay, they are not absolute in nature, so it means they can be restricted. Restrictions can be imposed. Restrictions can be imposed. Now, who is going to impose restrictions on fundamental rights? It is the duty of the government, or it is the task of the government to impose restrictions on fundamental rights. But these restrictions should be reasonable in nature. Okay, in Hindi we call it as jayaz. So if you are not able to understand the word reasonable, it means it is the duty of the government to impose restrictions, but these restrictions should be jayaz. सरकार जो पाबंदियां लगाएगी वो जायज होनी चाहिए. So the restrictions are reasonable in nature. We also call reasonable in Hindi uchit. Uchit pabandiya लगाना है ना. So government can impose restrictions, but these restrictions should be reasonable in nature. Government cannot impose any restriction which is unreasonable. It has to be reasonable. Now who will decide whether the restriction imposed by the government is reasonable or not? Whenever government will impose restriction, it is going to admit, it is always going to say that we have imposed a reasonable restriction. Government is never going to admit that the restriction imposed by the government is unreasonable in nature. Government is always going to say that the restriction imposed by us is reasonable in nature. So who is going to decide whether the restriction is reasonable or not. It is the duty of the court to decide whether the restriction is reasonable or not. So who will decide whether the restriction was reasonable or not? It is the duty of the court. Because for government, all the restrictions are reasonable. It is the duty of the court to decide whether it's reasonable or not. So I hope it is clear. So for those who are not able to understand what is the meaning of the word absolute, absolute means we can in Hindi call as असीमित. So they are not असीमित in nature. इन पर उचित पाबंदी लगाई जा सकती है. Okay. So I hope the second point is clear. Now the third point. So the third point is they are not permanent in nature. They are not permanent in nature. So when I say fundamental rights are not permanent in nature, it simply means fundamental rights in future can be amended or repealed. Now I have a proof. Now the proof is earlier there were 7 fundamental rights and now there are total 6 fundamental rights. So we will discuss this later on, which fundamental right was repealed by the government. So they are not permanent in nature. It means they can be amended. They can be amended or repealed. So repeal means to abolish that fundamental right. So I hope this thing is clear, that they are not permanent in nature, they can be amended or repealed. So this is the third feature of fundamental rights. And now let us start with the fourth feature of fundamental rights. The fourth feature of fundamental right is what we have already discussed. You know that during national emergency fundamental rights can be restricted. So this is also a feature of fundamental rights, that fundamental rights during national emergency can be suspended. They can be suspended during national emergency, which is under Article 352. And we have discussed this in detail, that there are 2 articles in the Constitution, Article 358 and Article 359. These 2 articles explains the effect of national emergency on fundamental rights. And what we discussed in that class, that whenever the national emergency imposed, there are few articles which are always alive, they are never suspended. And let me write it, because some of you might not be present in that class. So national emergencies of 2 types, external and internal. So during external emergency, except these 2 articles, all other fundamental rights may be suspended. And during internal emergency, except these 3 articles, remaining fundamental rights can be suspended by the president. Okay, we discussed this, that the president under Article 359 can issue an order, and if in that order there is any fundamental right, then yes, that fundamental right will be suspended. But in reality, that fundamental right is not suspended. The enforcement of that fundamental right is suspended. So it means fundamental right is theoretically alive, but its enforcement is suspended. So this we discussed in Article 359. So I hope we already discussed this. Now another feature of fundamental rights is, see, ideally fundamental rights are given to the citizens of that country. Fundamental rights are for the citizens of that country. But there is something unique about the Constitution, or something special about the Indian Constitution. The special about the Indian Constitution is that there are few fundamental rights which are also available to citizens. So see, all the fundamental rights are available to citizens, but there are few fundamental rights which are also available to a foreigner. Why? Because you are a human, and because you are a human, you are supposed to have these rights. You cannot be treated as an animal in our country. So you should have these rights when you are in our country. So this is the next feature of fundamental rights, that some fundamental rights are available. Some fundamental rights are available to foreigners also. Okay. Now what are those fundamental rights? Now this is important for examination. You must know what all fundamental rights are available exclusively to citizens and what all fundamental rights are available to all. So let us write those fundamental rights which are available only to the Indian citizens. So those fundamental rights which are available only to the Indian citizens is, I mean 15, 16, 19, 29, 30. These articles are available only to Indian citizens. On this side, we will write those articles which are available to all Indian plus foreigners, except enemy aliens. See, foreigners are aliens, but aliens are of two types: friendly alien and enemy alien. So we are dealing with the friendly aliens. Okay, those citizens with which we have friendly relations. Okay, they belong to those countries with which we have good relation or friendly relation, and enemy aliens are those with which we are at war. So these articles are available to all: 14, 20, 21, 21A, 22, 23, 24, 25, 26, 27, now 28. So these are the articles available to all. Now one thing you have to remember: if you will read all these articles, you will ask this question, and the question should be, sir, what about the articles 17 and 18? Why these articles are missing? The answer is simple. Article 17 and Article 18 deals with abolition. Okay, so they are merely the abolition of certain things. Article 17 is the abolition of untouchability. Article 18 is the abolition of titles. So they basically discuss about the abolition of untouchability and titles. So that is why there is no need to write them either in this part or this part. Okay, so I hope this thing is clear, that what about the Article 17 and 18 and which all fundamental rights are available exclusively to Indian citizens. So I hope we are done with the important features of fundamental rights. So with this, the important features of fundamental rights are over, and now we can start with the how many articles are there in the Constitution dealing with fundamental rights. Now remember, originally there were total 7 fundamental rights. How many? There were total 7 fundamental rights, but at present we have only 6 fundamental rights. So what happened with that one fundamental right? So first we will write all those 7 fundamental rights, and then we will discuss what happened with that one fundamental right. And I know you might be aware of that, what happened with that fundamental right which was repealed in 1978. But for those who don't know, just wait and watch. Okay, so how many fundamental rights were there initially? There were total 7 fundamental rights. Now, the first fundamental right is right to equality. And one more thing, remember, questions from this area also appears in the examination. I have seen many times in the question paper that question is coming from these area. Now, what is this area? Right to equality deals with Article 14 to 18. So, sometime question comes in the examination that Article 14 to Article 18 deals with the first option, right to equality, second option, right to freedom, right against exploitation, right to constitutional remedies. So, remember, Article 14 to 18 deals with right to equality. Or the question can come in other way. For example, right to equality consists of how many articles? First option, Article 14 to 18. Second option, Article 19 to 22. Third option, 23 to 24. Fourth option, 25 to 28. So you have to remember the sequence and what all articles are in this right. Okay. So right to equality deals with Article 14 to Article 18. Now, another right. Right to freedom. So, how many articles are there in right to freedom? Article 19 to Article 22. Okay. Now the third right. The third right is right against exploitation. Right against exploitation. Article 23 and 24. Fourth, right to freedom of religion. Right to freedom of religion. Article 25 to Article 28. Then, fifth. The fifth is cultural and educational rights. Cultural and educational rights. Article 29 to Article 35. Now, sixth is right to property. Right to property, Article 31. And the last fundamental right is right to constitutional right to constitutional remedies. Article 32. Now, for your examination, you should remember the sequence and which set of article comes under which right. So, right against exploitation deals with Article 23 and Article 24. Right to freedom of religion, Article 25 and 228. Okay. Now, so initially there were total 7 fundamental rights, but at present how many fundamental rights are there? Only 6 fundamental rights are there. So what happened with that one article? So which was that article? I know you all are aware of it. It was the right to property. So it was the right to property which was repealed by the government. This article was repealed by the government. Which government? The government was Janta government. Who was the Prime Minister? Morarji Desai was the Prime Minister. Morarji Desai was the Prime Minister. So it was during the rule of Janta government that the government decided to repeal the right to property, because we all know that while studying basic structure, what we discussed that right to property was like an obstacle in the path of land reforms. Government wanted to introduce land reforms to ensure justice, equality. Okay, land can be redistributed among those who were landless. So land reforms was one of the biggest tasks of the government after independence, and right to property was seen as an obstacle. So that is why in 1978, by the 44th Amendment Act, Janta government decided to repeal it from this category. So it was the Janta government which enacted 44th Amendment Act 1978, and it was by this amendment that right to property was repealed. But remember one thing, right to property was repealed, but it doesn't mean that right to property does not exist anymore. Right to property is present in the constitution, but the location and status of right to property has changed. Why I am saying that both have changed? The reason is simple. Initially or earlier, right to property was under part 3rd of the constitution under article 31. At present, right to property is present in the constitution, but it is not under part 3rd of the constitution. It is under part 12th of the constitution. So the location of right to property has changed, and also the status has changed. Why I am saying status? Earlier, right to property was a fundamental right under article 31 of the constitution. But at present, right to property is not a fundamental right. Right to property is a constitutional and legal right. So many times students are confused with this, that whether right to property is a whether right to property is a legal right or constitutional right. Right to property is a constitutional as well as legal right. So I hope this thing is clear, that the present position of right to property is under part 12th of the constitution. So let me write this, that at present right to property. So at present, what is the location of right to property? It is under part 12th of the constitution, article 300A. So this is the present location of right to property. Second, what is the present status of right to property? This is the location. So right to property at present is a constitutional as well as legal right. Legal right. So remember, right to property was not removed from the constitution. It was only removed from the part 3rd of the constitution. So we still have right to property, but not as a fundamental right, but as another right. So this is the present location and status of right to property. So I hope you will remember this point, that what happened with the right to property. So I think we are done with the story of right to property. So after this, there is one more question that I should answer before I move further. Okay, and I was expecting that you should have asked this question, and this question should be, first of all, let me consume. Okay, so the question should be that, sir, in the starting you said under part 3rd of the constitution, articles start from 12 to article 35. So initially I said that the articles are from 12 to 35, but while writing those 7 fundamental rights, I started from article 14 and ended at Article 32. So, while writing fundamental rights, what I did? Initially, I said it is from 12 to 35. But while writing 7 fundamental rights, I started from Article 14 till Article 32. So now the question is, what about the remaining articles? What about Article 12, 13? What about Article 33, 34, 35? What happened with these articles? Are these articles not to be considered as fundamental rights? Yes, these articles are not fundamental rights. These articles are related to fundamental rights, but there is no fundamental rights in it. So that is why first we will discuss what are these articles, because these articles are related with fundamental rights. Okay, so let us start Article 12, 13, 33, 34, 35, and then we will start with article number 14. So let us start article number 12. So what is Article 12? Article 12 deals with definition of state. Okay, now remember, if you are preparing for railway examination, then you do not have to remember what is written inside Article 12. I mean, that is not frequent enough. Okay, so for you, what is important? That Article 12 deals with definition of state. So even if you don't want to remember the entire article, what all provisions are there in this article, you can simply remember that Article 12 deals with definition of state. But suppose if you are preparing for higher examination, for example defense, or for PCS examination, that is state civil service, or for union public service commission, I mean central civil service examination. So whenever you are preparing for higher examination, the tendency is that they might ask the questions related to the provision of that article. So basically the heading of Article 12 is definition of state. So for lower examination, definition of state is sufficient. But since we are studying, we also need to understand what are the provisions of it. So suppose if tomorrow the examiner decides to ask Article 12 in detail, then you should be in a position to answer that. Okay. So, but this is important for you. What is the heading of Article 12? Now, why we are saying definition of state? So suppose I ask this from a layman, from a normal person, that what do you mean by the word state? How would you define state? So some might say that state means land, population, government, sovereignty. Some other might say state means we have 28 states in our country. So for some other, state means this, for some other, state means that. But what is the exact definition of state? And why we are discussing about the definition of state? The reason is simple. These fundamental rights I discussed in the starting, that these fundamental rights are like your power against the government. Government means the state. So here state basically means government. Now, it is important for the constitution to define what is meant by the term state, because these fundamental rights are available against the state. So while reading Article 15, you will find that yes, the word state is mentioned. So in many fundamental rights, the word state is mentioned. So it might be a problematic thing for you, that what is the word state here. So according to Article 12, the word state means Parliament and Government of India. And remember, see, Parliament means legislature, Government of India means executive. So legislative and executive organ of the union government. Second is the legislature and executive organ of the state government. So legislative organ of the state government is a state legislature, and executive organ of the state government is the government of state, basically dealing with the ministers, state legislature and government of state. So this is the legislature, this is the executive, legislature, executive. So legislature and executive organs of the central and state government forms a part of Article 12 definition of state. Now third, all local authorities. All local authorities. So when we write all local authorities, it automatically includes panchayat, because panchayat is a local government, municipality is a local government, and any other local authority which exists in your region or in any other region. So panchayat, municipalities falls under local authority. Now fourth, all other authorities. All other authorities. Now remember, this is important. What is meant by all other authorities? Now it is for the court to decide whether a particular authority comes under the definition of state or not. For many years ago, this question was asked from the court that whether BCCI, the governing body of cricket in India, falls under the definition of state. So many times such question comes in the examination. I mean, such question comes before the court that whether this particular body can be considered as the state under the Article 12. So it is for the court to decide whether a particular authority can be deemed to be can be deemed to be an authority under Article 12. So what we can expect that all the government bodies, for example, we all know LIC, it is a government body. We all know all other, for example, GAIL, SAIL, BHAIL, all these PSUs, public sector undertaking, the companies established by the government, ONGC. So all these companies that you see which are established by the government, see, government also has the right to run business. Government has the right to run business, and in India we see government is running business. For example, BSNL, state-owned telecom company. Earlier, Air India was state-owned airlines. So in India we have government-run companies. So government also has the authority to run the business. So the entities created by the government also falls under the definition of state under Article 12. So again, it is for the court to decide whether a particular body will be considered as a state or not. So remember, this is the definition of state. So whenever, while reading fundamental rights, if you ever encounter the word state, then remember that state does not mean land, population, sovereignty, government. That state does not mean the 28 states of India. The state means what is mentioned in Article 12 of the Constitution. So I hope this part is clear. And remember, this list is open-ended. It is not exhaustive. It is open-ended. It means with time, Supreme Court with time can add more and more bodies under the definition of state. And it will be good for you if more and more authorities and more bodies are added in the definition of state, because fundamental rights are against state. If more and more authorities are included under the definition of state, then you will be having protection against all those bodies also. Okay, so that is why this list should be open-ended. Okay, so Article 12 is done. Now we can start with Article 13. So again, Article 13 is an important article. Now what is the heading of Article 13? So for those who are preparing for basic examination, railway and all, so what they can remember, Article 13 heading is laws inconsistent with fundamental rights. Laws inconsistent with fundamental rights. So now remember, many times questions have been asked from this particular article, because in this article there are lot many things which we have to discuss. So first we will discuss that what is the Article 13 dealing with. So Article 13 basically deals with that any law which is inconsistent with or in violation of any of the fundamental right, then such a law can be declared as unconstitutional or invalid, and then such a law cannot be enforced by the government. So Article 13 means, suppose government made a law and now that law is violating a fundamental right. Now as per Article 13, if any law violates fundamental rights, then it is the duty of the court to ensure that such a law remains invalid or void. So whenever court finds that the law made by the government is violating your fundamental right, then the court has the power to declare that law as unconstitutional or invalid, and consequently such a law can never be enforced by the court of law. can never be enforced by the government. So I hope this particular thing is clear, that what is Article 12, sorry, what is Article 13. So the first point that we have to discuss in Article 13 is that whenever a law is made by the Parliament or the state legislature, any law which violates any fundamental right, then such a law shall be void or invalid or unconstitutional. And who will declare that the particular law is unconstitutional? It is the duty of the court. Now remember, this particular article deals with examining the laws. Okay, this article is dealing with examining the laws. Why we have to examine? We have to constantly examine laws in order to identify whether they violate fundamental rights or not. So this article deals with examining the law. And whenever we hear the word examining the law, it basically means we are talking about judicial review, because judicial review means to examine the validity of a law, to check whether that law is constitutionally valid or not. Okay, so remember, this article deals with judicial review. And judicial review means to examine the constitutional validity of any order or law passed by the government. Because in our country, constitution is supreme. No other law should be above constitution, or no other law should violate the constitution. So whenever this happens, it is the duty of the court to declare that law as unconstitutional. And whenever the court does this function, we basically call it as the power of judicial review. So judicial review means to examine the constitutional validity of laws and order passed by the government. I am unable to see the comment. See, right now I cannot tell you the date that when this batch is going to be launched, but right now we are just giving you the demo lectures, that how we will how the things will proceed in the actual batch. So right now you just study with whatever you have, I mean what we are teaching, and whenever the batch will be there, we will inform you. Okay, so stay connected with us and we will surely inform you whenever the batch is launched. Okay, and obviously the batch will be launched on this channel, so you don't worry about that. You just have to wait for it. Okay. See, right now we do not have any pre-recorded. See, we have just started this channel, so at present we do not have any pre-recorded videos. So you just have to wait for this. Right now you can just see the videos that are already available on the YouTube on this channel. Okay, I have discussed different chapters on YouTube. So okay, so right now you can learn from that, and once the batch is launched, see in the batch all the classes will be in systematic manner, and we will also be providing written notes. See, right now these are the handmade notes in the class, but we will also providing the printed notes in a proper systematic manner. Okay, along with the MCQs that we'll be discussing in the class. Okay, so there are many things which we will be offering afterwards. Okay, so I hope. Okay, welcome. Okay, so let us assume. So I hope you are clear with judicial review. So if whenever suppose if this question comes in the examination, that suppose this statement comes in the examination that Article 13 deals with judicial review, then that statement is correct, because judicial review basically means to examine any law. Okay, now one more thing. According to the Constitution, the power of judicial review is vested in Supreme Court. According to the Constitution, the power of judicial review is vested in the Supreme Court under Article 32 and in High Court under Article 226. So this article deals with judicial review, and the power of judicial review is vested in Supreme Court under Article 32 and in High Court under Article 226. This is also important for examination, that see, now remember, Supreme Court and High Court are considered as higher courts, and now below higher court there is lower court. Lower courts do not possess the power of judicial review. Judicial review is the power with the higher judiciary, that is Supreme Court and High Court, not with the lower court. Okay. So I hope the third point is clear. Now the fourth point. The fourth point is Article 13 deals with the word law. I mean, it is clearly mentioned any law which is inconsistent with fundamental rights. So Article 13 deals with the word law. So in Article 13 it is also mentioned that what is meant by the word law. So under Article 13 you will find the meaning of word law. So law means all those laws which are permanent in nature. So all the permanent laws comes under the definition of law under Article 13. So permanent laws are basically those laws which are enacted by Parliament and state legislature. Now, if there are permanent laws, then there are temporary laws. Now, temporary laws are also known as ordinance. Ordinance are discussed separately in the chapter the President of India, because when we will be studying the power of the President, we will study three main power of the President: veto power, ordinance power, and pardoning power. So ordinance will be discussed in the chapter President. So ordinance are temporary laws, and these ordinance are passed by the President and Governor. So President and Governor issues ordinance. Okay. Now permanent laws, temporary laws, and third, all those which are not considered to be as a law, but they have the effect of a law. So suppose government passed an order, or government made a rule, issued a notification. Now remember, these are not considered as law. Okay, but their effect is somewhat akin to a law. So if you do not obey the rule of the government, then you will be punished. So even if it is not a law, the effect of that rule, order is like a law. Okay, so we can compare these orders, rule with law when it comes to Article 13. So because they have the effect of a law. So even the law, even the orders, rules, notifications passed by the government are also considered as law, because you will be punished if you do not obey these rules, orders. Okay. So now fourth, all the customs and traditions are also considered as part of law. Now remember, customs and traditions are not law, but for those who are following a particular religion, for them that custom or tradition is really important. And if you are a follower of a particular religion, then we all know that in any religion there are some customs and tradition, and for those who adhere to that religion, they have to abide by their custom and tradition. So these customs and traditions also have the effect of law on those who follow that religion. So suppose if there is a custom which violates fundamental rights, suppose there is a custom in which there is a discrimination between men and women, then such a custom can be challenged in the court on the ground that it violates fundamental right, because we have to give supremacy to fundamental rights, not to the custom and tradition. Because in our society there are many customs and tradition which are patriarchal in nature. It means these customs and tradition solely benefits the male, not female. These custom tradition many times they oppress women. So there are many traditions in our society which are oppressive in nature, which suppresses the women. So that is why if any custom or tradition violates fundamental right, basically discriminating between men and women, imposing certain conditions or restrictions upon women, then that such a tradition or custom should be challenged in the court of law. And why it will be challenged? Because as per Article 13, customs and traditions are also a part of law. So they can also be challenged on the ground that they violate fundamental rights. So customs and traditions are also part of law. Then there is one clarification under Article 13, and that clarification is Constitutional Amendment Act. Let me write this with in a different color. Okay, the fifth point is constitutional amendment acts are not to be considered as law under Article 13. Now remember this, for those who attended the lecture of basic structure, in the basic structure chapter, I discussed that after Golaknath case, Parliament reacted by enacting the 24th Amendment Act. By the 24th Amendment Act, Article 368 and Article 13 were amended, and when the Article 13 was amended, it was mentioned in Article 13 that constitutional amendment acts are not to be considered as law under Article 13. And why this was said? Because in Golaknath case, Supreme Court said that Constitutional Amendment Act should also be considered as a law under Article 13, and any law which violates the fundamental right will be invalid or unconstitutional. So that is why the government, by the 24th Amendment Act, amended Article 13 and inserted this provision in Article 13 that Constitutional Amendment Acts are not to be considered as law under Article 13. So this was a clarification, so that in future Supreme Court understand that yes, Article 13, Constitutional Amendment Act is not a law under Article 13. So this was the clarification, which was basically to nullify the judgment of Golaknath case. So yes, these are considered to be as a law, and this particular thing is not to be considered as a law under Article 13. This provision was added by 24th Constitutional Amendment Act 1971 during Indira Gandhi government, and we have discussed this separately in basic structure doctrine chapter. Okay, so with this we are done with Article 13. Okay, so today we will discuss these articles 12 and 13 and the features of the fundamental right. So from tomorrow, tomorrow is Tuesday. So tomorrow we will start with Article 33, 34 and 35. So first we will discuss these three articles, and then we will start with article number 14. So from article fundamental right starts. So right now we are discussing those articles which are related to fundamental rights. These are not to be considered as fundamental rights. You can see we have not discussed any fundamental rights, but we are just discussing that what Article 13 is saying, that if any law violates fundamental right, then that law is to be declared unconstitutional. So right now we are just discussing about the things related to fundamental rights, but the actual fundamental rights will start only when we complete Article 33, 34 and 35. Okay, so goodbye everyone, and tomorrow same timing 8:30 to 9:30 we will start with Article 33, 34 and 35 and the remaining fundamental rights. Okay, so thank you everyone.